curator ad litem, someone who is incapable of handling his or her own affairs. Now, if you recall, yesterday we were in a consultation, and we are going to now find out how we are going to help our client. So I said the first thing that you have to do is find out if he has a case. We looked at causes of action and what you as the legal practitioner must keep in mind when you do consult. And we looked at, what did we also look at? Yeah, apart from opening the file and that, but I just want to speak, we looked at the cause of action and the locus standi. And a person of to be declared of unsound mind is the situation where you would apply to have a curator bonis appointed for that person. Right, a person who can't handle his or her own affairs. Obviously, the person must have an estate. If the person doesn't have an estate and he's just been diagnosed with Alzheimer's disease, doesn't mean you're going to have him declared incapable of handling his own affairs if he just receives a monthly pension from the government. I mean, right. So if there's no questions, I just want you to also take heed of the following. And I presume that I am sharing with you because that is the indication that I'm getting. Am I sharing with you? If I'm not, then I'm on slide 60 for those of you.
Yes, you are.
Oh, I am. Thank you for
Yes,
that.
ma'am, you are.
Right. These are the following people that you must have a look out for also with regards to locus standi. Right? If somebody comes to you and that person has been declared a prodigal, remember they have limited capacity to act because somebody, do you know what a prodigal is? Somebody who spends money recklessly, his own money, spends it recklessly. Family is concerned and they have him declared a prodigal, and then he don't have the right to spend his money as he wishes. Right? That is a prodigal. Can he institute legal proceedings? You'll have to consult with whoever has been appointed to deal with his estate. Right. A person who has been declared insolvent, can they institute proceedings? Yes, they can. But remember, there has been a trustee who has been appointed, who is in charge of the insolvent estate. So that trustee must be known. If an insolvent wants to defend any case against him, then you don't need the trustee's permission because he can defend. Another person or another type of party that you have to look out for is the fugitives from justice. This is a party, you cannot represent somebody in court who's running away from the law, right? In a civil matter. Like your Thabo Bester kind of people. Okay. Then alien enemies. Alien enemies, those are citizens of countries with which we are at war. You can't represent them, but we are not at war with anyone at the moment, but just remember that. And the interesting one is diplomats. We all remember the case of Grace Mugabe when she was still the first lady of Zimbabwe, and she came to South Africa and she assaulted someone, and they said she can't be charged because she has diplomatic immunity. Now, the same goes for civil claims. Can you claim from a person who enjoys diplomatic immunity? No, you can't. You would write to the embassy and ask that embassy if you can sue this person, but they must give permission. And it's all got to do with the sovereignty of the states. Remember, when you go into an embassy or a consulate of another country, then you're actually on that country's land. So if you're going to sue somebody that's there and that enjoys that diplomatic immunity, it's going to have grave consequences. So you have to inform the country and see if they will waive the diplomatic immunity. A list of people who enjoys diplomatic immunity is published on the website of the Minister of Foreign Affairs. So if you want to know whether a person enjoys diplomatic immunity. Your client comes to you and says, this person is he works at the consulate, and he ran into me with his vehicle. We collided, there was a collision, and now I have damages and I want to sue him. Then you have to find out. Okay, so that is also where locus standi is concerned. Then judges. Remember, if you want to sue a judge, you have to first get the permission of the judge president in the division where that judge is seated. So you would write and say, I want to sue judge so-and-so for this reason. And I'm not talking in the capacity of judgments that they have made, handed down, not in the capacity as a judicial officer, but as a person. Okay, there's some background noise. Yellow. Yes, somebody's microphone is on. Can you just put it off, please? So the judge, say the judge comes and he defames you in the road. He don't like you and he says something nasty about you in a meeting, and it's defamatory and it causes you damage, and you think you want to sue him. You first have to ask permission of the JP in the division where that judge is sitting. And if he gives you that permission in writing, then can you institute proceedings against the judge. And then members of parliament, when parliament is in session, then you have to sue them out of the Western Cape High Court, because then that is regarded as their house, as their domicilium. And partnerships, firms and association, remember, when you sue one partner, you must serve on each and every partner. Just remember that. So this is all under locus standi, and these are what you have to look out for. Right? This is not in your manual, but just know that we're sitting in our consultations, and we must think as lawyers, and we must check for these things if we can. Right? Any questions on locus standi? You already know that, right? Let's move on to the next slide, which is slide 61. It's got to do with jurisdiction. Now, I know that you know jurisdiction, so I'm not going to visit long at jurisdiction. We all know that jurisdiction is the competence that a court has to hear and determine an issue between the parties before it, right? The first issue is the geographical court. Which court, sorry, the type of court, which court has jurisdiction to hear the matter? For example, the High Court, the Magistrates Court, the Labour Court, the Income Tax Court, or another specialist court like the Competition Commission, the Land Claims Court. They are all different kinds of courts that deals with different kinds of matters. Right? Like, for example, you wouldn't bring an unfair dismissal claim to the High Court because the Labour Court has jurisdiction to hear that. Okay. Then you look at the geographical area, and then you can decide what court has jurisdiction to hear the matter. Okay, that is exactly the same. I don't know why I have it twice. Now, in section 21 of the Superior Courts Act, it tells us the persons over whom and matters in relation to which the divisions have jurisdiction. Now, you can look at page 68 of your manual, where it tells you what section 21 says. It's not on my slide. It says that a provincial or a local division has jurisdiction over all persons residing or being in the area of jurisdiction in relation to all causes arising within the area of its jurisdiction, or in relation to all matters to which it, according to law, may take cognizance of. In those instances, the court has jurisdiction over a person. Now, to take you way back to your studies, you will remember these Latin phrases from your studies. The ratione domicili ratione rei gestai, ratione rei sitai. The ratione domicili is used to, where the defendant, the court has jurisdiction, where the defendant is either resident or domicile. Okay. Also called the principle of actur sequitur forum rei. So you take the case to the forum of the defendant and institute action in the court where the debtor resides. Right. Then the ratione rei gestai. That is the reason where the cause of action arose. And the ratione rei sitai is where property is situated. That court would have jurisdiction. Right. Domicili, I've already said that, where you follow the defendant, also the actu, what is that word? Actu sequitur forum rei, right. Rei gesta is where the cause of action arose, right? If it's in terms of a contract, then the court where in the area where the contract was entered into has jurisdiction, and if it was performed in a different part of the country, then that court would have jurisdiction. If it is breached in another part of the country, then that court would have jurisdiction. With a delict, it's where the cause of action arose. That court will have jurisdiction to hear the matter. Right. Where property is situated, immovable property, it depends, sorry, where the property is, if you are claiming transfer. Sorry, if you are claiming title, where the property is. But then you can use any of the other reasons if you are claiming transfer. Just look at that. And then if it's movable property, you can also use any of the reasons. Reisitai, court in whose geographical area of jurisdiction the movable property is. Reigestai, where the cause of action arose. Or domicilium, you follow the defendant to where he is. And then if a claim is sounding in money, then it depends on whether when the court has jurisdiction, whether the person is a peregrinus or an incula. Now, does you also remember from your studies, an incula would be a person living in that specific area, or an incula of South Africa, or an incula of a specific division, right? You will use the ratione domicili or the ratione regestai, where the cause of action arose, or where the contract was entered into, yeah. If the defendant is a peregrinus, that means is a foreigner, then the court does not have jurisdiction unless you attach his or her property to find jurisdiction. Now, in the past, they used to arrest people to confirm jurisdiction, but that has been declared unconstitutional. Okay, and then obviously it's not here, but you always can submit to the jurisdiction of the court by not challenging the court's jurisdiction if you are sued, or you can explicitly submit to the jurisdiction of the court. But remember, the court must be able to deal with the matter, because you can't submit to the jurisdiction of the land claims court if it is an eviction in terms of pie. Then you say, okay, I want this court, I submit to this jurisdiction. It must make sense. Right? If you, for marriages, you know, for divorces, marriages who ends, that ends in divorces, from your studies, one of the parties must have lived or be domiciled in the area of jurisdiction of the court for a year, at least a year. For those of you who are doing articles and you've done divorces, one of the questions that you will see, even if it is an unopposed divorce, one of the questions that you ask is, do you regard the Western Cape as your permanent residence? Because you must establish jurisdiction. And how long have you been living there? Okay. Are there any questions on jurisdiction?
Counsel, can you hear me?
Yes, I can.
Yeah, if I can take you back, you did mention that you can't bring an unfair dismissal to the labor court. But then I see section 157 of the Labor Relations Act states that the High Court exercises concurrent jurisdiction with the labor court.
Only in certain matters.
All right.
Not an unfair dismissal. You can, if you are an independent contractor, then you can either for breach of contract go to the High Court or the Labour Court. Then they have concurrent jurisdiction. But a normal unfair dismissal matter where you are an employee, you don't, the High Court doesn't have jurisdiction because the Labour Court has. That is the wrong forum. Yeah.
All
So
right,
the
thank you.
157, they do have concurrent. If you're an independent contractor and you want to sue, you can decide which court are you going to sue in. Are you going to sue based on contract, breach of contract, or are you going to go for the unfair dismissal? But for unfair dismissal, you must be an employee. And for those of you who are into labor law, you know, an employee, you must meet certain criteria, and not independent contractors doesn't necessarily meet that criteria.
Thank you.
Okay. Is there somebody that can't hear me? Has that been sorted? I see the chats. Oh, thanks, Joshua. Oh, I had some fun reading your chats yesterday, last night when we ended. I see some people yeah, are annoyed at other people. For those of you who for asking questions, for those of you who are unsure about career paths and career choices, and you just need to speak to somebody who may know a little bit more than you, feel free to send me a WhatsApp. I'll assist you on it, because I don't want you to go away here and not know where you want to direct. So yesterday people asked questions and other people got annoyed with it. But I am open to those kind of questions. You can do it privately then, and not upset the rest of the class. For those of you who think I may be able to shed some light. If I don't know, we can find out together, or you can go find out. But I know it is important that we know where we're going. But I'm going off topic because that was also one of the complaints that I read. Let's go on. Is there another question on jurisdiction? None. Okay, let's move on. Right. Now, now if we're going to do, you do know already that there's two kinds of procedures. There's the action procedure and then there's the application procedure, right? The action procedure is the one that ends in a trial. Now, at a trial, you call witnesses. So at a trial, you lead oral evidence. That is the action procedure, right? So it usually starts with the summons. And if the matter is not settled, it ends with a trial. That is the action procedure. The application procedure, it starts with a notice of motion and affidavits, and it is decided on the papers. Right? So application and motion are used interchangeably. Action and trial are used interchangeably. Just know. Right. So with the application, you're not going to call any witnesses. You are going to have all your evidence on paper in an affidavit, and it is sworn to, so it is evidence. Remember, the court can only consider evidence, and if the evidence is not before the court can't consider it. So in an application, the evidence is in the form of an affidavit. So if your affidavit is not commissioned properly, your opponent will raise the fact that there is no evidence that the court has to make a decision on. So that is why you have to have your affidavit commissioned properly. You look at the Commissioner of Oaths Act and see what are the requirements that you must meet in order for it to be commissioned properly. Yeah, and all lawyers are ex officio commissioners of oath. You do know that already, eh? So I don't know if candidate attorneys are, I don't think they are, but when you're admitted as an attorney, you become an ex officio commissioner of oaths, right? And then there's certain things when you do commission, there's usually, and we are all guilty of it. You do a cut and paste thing with that last paragraph because it quotes the legislation and all of that. I'm not talking about that Commissioner of Oaths thing. There was a case where Commissioner of Oaths commissioned an affidavit and he didn't, the attorney who drafted it and everybody overlooked. It was male, but it said, she said that she understands the content, something like that. It referred to a different, do you say gender or sex? Gender, to a different gender than what the person was. And the court said that that is not signed properly. So it's not evidence. Because how do we know that the commissioner in fact saw the person? Because we take it that if the commissioner saw the person and the person signed it in front of him or her, he would have seen that reference is incorrect. And as I say this, and I hear myself, I'm thinking, oh yes, but now we have all these different kinds of genders. So how are we going to deal with it if somebody says they say that they are, or them, or and sometimes a male can identify as a she. Yeah, it's wide open. Yeah, let's not go there because we can discuss it the whole night. But remember, that is the way the evidence gets before the judge. In the action procedure, the evidence gets before the judge by calling a witness, and the witness is also under oath. If they forget to swear in the witness, but they won't forget because usually the judge's secretary, the judge's registrar, as we refer them, will swear the person in, the witness in, and then evidence will be taken. If they forget to swear in the person, then it's not evidence, and it's not under oath, and it's just a statement. Right. Now, the main differences, this table is in your, it should be, it always has been. Let me just see, I haven't looked at it for a long time. No. I don't know, it's not here.
Page 74.
74, okay. The main difference between the two forms of proceedings. The parties in an action are called plaintiff and defendant, and it deals with substantial factual disputes. In an application, the parties are called applicant and respondent, and the disputes are not such substantial factual disputes because you want the court to deal with it on the papers. Right. Look, we can't say that there's no dispute of fact, because why are you in court? Because you disagree on something. So something is in dispute in this application, but the court don't have to listen to evidence. Evidence don't have to be tested by examining it. So it can be dealt with on the papers. That is what they mean with not so substantial that it can't be dealt with on the papers. Now, this is important. What we call the nomenclature. I think that's what they said. What we refer to the parties as. Because I've seen people draft, and you draft and you draft, and they talk about it's an action, and it's a plaintiff and a defendant, and then further on they talk about applicants. The applicant says whatever. Then they refer to the party as something else in another proceeding. Remember, an action, when you do the summons particulars of claim, it's a plaintiff and a defendant. And an application, it's an applicant and a respondent. Don't get confused and cross and call them both names, right? The action starts with the issuing of a summons by the plaintiff, and then there are further pleadings that are exchanged. So once the plaintiff issues the summons, the defendant files a plea. Okay, there's other things that happens in between. We get there. I'm just talking about the pleadings. The defendant will file a plea, and if the defendant has a counterclaim, he files the counterclaim to bed together with the plea. It's also called a claim in reconvention. And then the plaintiff, who is now the defendant in the counterclaim, will file a plea to that and file a replication to the main claim. Right? That is now if there are two claims running together. After the exchange of pleadings in actions, then there's a period where we do the practical arrangements, as you already know. That is where we have discoveries, pre-trial conferences, case management cases, judicial case management hearings. When we have all those practical arrangements, that period happens, right? And only after that, and the matter is then allocated with a trial, that then you go to trial and you call your witnesses. That is why it takes so long for you to get a trial date, because it's a long procedure. With applications, you have the notice of motion, and usually attached to the notice of motion is the affidavit where you set out the support for the relief and the case. You set out the whole case in the affidavit. We refer to that as the founding affidavit. Then the respondent files an answering affidavit, or sometimes referred to as an opposing affidavit. I think the rule says an opposing affidavit. People also call it an answering affidavit. And after that, the applicant files a replying affidavit. And then that is the end of it. Then the matter is set down for trial. And it's then argued by the legal practitioners. If you do want to file further affidavits, you can't just file another affidavit. It's not allowed. You have to actually bring a formal application to file further affidavits. And then you must convince the court that you have a good reason as to why that information has been left out in your original affidavit, and that the court should allow it, because the court won't just allow you to file further affidavits. And obviously your opponent will also object. Right. Now, after the plea and the counterclaim to the plea and all of that, and the replications in the action, there is still further pleadings, which I'm going to show you later. But there are other pleadings that can also be exchanged if the parties want to join further issue. I've seen one or two of it in my 21 years at the bar, and before that, I didn't see any of that. But there are further pleadings that can also be exchanged before we actually get to the litis contestatio. State that litis contestatio means close of pleadings. Right.
Counsel, a quick question, if I may, please.
You may.
Regarding the application procedure, in terms of the High Court rules, the Rule 35 discovery notices, is that only applicable to action, or is it also allowable in application?
Just say that again. You want to know if you can ask for discovery during applications.
Indeed.
You can, but it's not a requirement. But people have utilized those if they need certain documents. You can. It has been done, but it's not as a rule done. But if you need certain documents from the one party, you can. But remember, you fall and stand by what is in your application. But there is in the rules, and you would know this in the match court discovery, the rules is Rule 23. In the High Court, it's Rule 35. It is exactly the same. Now, Rule 35.14 in the High Court rules, that is where you can ask your opponent to give you a document which they refer to in the particulars of claim, so that you can look at that document in order for you to plea. And that I have seen utilized in applications as well, where the applicant in these founding affidavits refer to documents, and then the respondent does a 35.14 where he asks for discovery of that document so that he can plea, because he don't have that document. So yes, I have seen that.
Thank you, counsel.
Okay. Right.
Sorry, counsel.
Yes. Oh, another question. Yes.
Yes, sorry to interrupt. I'm trying to raise my hand, but
sorry.
having challenges. I would like to ask for a matter that, for a labor matter that went from the CCMA to the Labor Court, which application should be used? Is it the, I mean, which process should be used? Should it be the application or the action for a matter?
Tell me, is it for unfair dismissal or is it for unfair labor practice? What is it?
For unfair dismissal.
And now you want to bring it into the labor court. Okay, yes. So it went from the CCMA, and was it referred, because they have two kinds of procedure. If you had mediation and you had arbitration, and the arbitration was unsuccessful, then you can take that arbitration award on review. If it is referred to the labor court from mediation because it didn't settle, then you do a statement of facts. It's like an action procedure, a statement of facts.
Oh, okay. Thank you.
So you will also call witnesses in that. Yeah, but you did labor law in this. You did do you do a module on labor law, or don't you?
Yes, we did, but we were not informed in terms of, like, for a matter coming from the CCMA, let's just say you're unsuccessful there, then you are going to, let's just say you're taking the matter on review to the labor court.
That is
we're
an
not,
arbitration award that can be reviewed. But if there was no
Yes.
arbitration and it is immediate, it is directly referred. Like, for example, retrenchment of big companies. There's different categories of big retrenchments and small retrenchments. If it's a big retrenchment, then they mediated on it unsuccessfully, you immediately go to the labor court. Then you do a stated case, not a stated case, a statement of facts or statement of claim, and you have your plea, and you also call witnesses. Yeah, yes.
Sorry to
Okay,
interrupt.
thanks.
With all due respect, we are still to do labor dispute resolution from the 2nd till the 3rd of August. Could we please confine our discussion to the scope of this course?
Okay.
Thank you.
Sorry, counsel. I just wanted to understand in terms of application and action in relation to those matters, not necessarily that I was dwelling into labor law. Thank you.
Okay. Yeah. So, are there any other questions? Okay. When you are still in your consultation, right? We are still sitting there and the client has come to us. Now you must decide which procedure are you going to use. Are you going to use the action procedure or the application procedure? And how do you decide? Because if you use the wrong procedure, that can be fatal to your case. You must ask yourself the following 3 questions. First, you ask yourself, is the action procedure mandatory? Now, in certain cases, in certain kind of cases, you can only use the action procedure, only issue summons, plaintiff and defendant, right? For example, a divorce action, a divorce is always an action. It's never a application. A claim for damages, that is not a liquidated amount of damages, where damages has to be proved. The court must decide and determine whether in fact the damages and the amount of damages or the quantum of damages has been proved. So then you would always need an action. You don't need use an application. So if one of the mandatory categories is not present, and the answer is then no, then you must ask yourself the second question. Is the application procedure mandatory? Now, if the answer to that is yes, for example, if it's an application for sequestration or the application for the appointment of a curator, you must use the application procedure. And if the answer is no to that, then you must ask yourself the third question. I just want to come back to the first point, but I just want to finish this thought. The third question is, can I foresee a real dispute of fact? And if the answer is yes, then you must use the action procedure. And if the answer is no, then you may use the application. So the third thing is the application is not mandatory, the action is not mandatory. Now it's up to me as the legal practitioner, which procedure should I use? Now I must look at the facts. Is it a real dispute of fact? And by real, we mean, do we need to prove that the dispute, or can it be determined on the papers? And then we make that call and we choose the procedure. Just going back to the first one where I asked, when I said a divorce is one of the mandatory procedures for the action procedure. In some divisions, for those of you in Cape Town and in other divisions, you would see that unopposed divorces are heard in the unopposed motion court with the unopposed motions. In most divisions, I don't know how it works in all divisions, but in most of the divisions that I've been in, it's heard with the unopposed motions, but it is an action. And this is demonstrated when you call your witness, because in unopposed divorces, you must always lead oral evidence because it's an action. So one of the parties must be called. It can be the plaintiff or the defendant. Usually it is the plaintiff that you call, and then you ask the list of questions. The plaintiff gives oral evidence. You ask, is this your name? Were you married with so-and-so on that day? Are you still married? How many children are born? What was the reason for the breakdown? All of that questions, you would know it by now if you do that a lot. Yeah, I just wanted to bring that the divorce is an action, even though it is when it's unopposed, heard in the unopposed divorce court, in the unopposed motion court. Okay. Right, so you must now decide, and let's.
Sorry,
yes, you may ask.
I'm so sorry to interrupt.
You mustn't apologize for asking me a question, because that's what I'm here to answer. Yes.
No, but sorry, yeah, Advocate, I just want to find out. So, for example, if you have an eviction, which is obviously an application, but they also are in arrears with their rental, which will then be an action. How do you go about it? Will it also still be two different, proceedings, or can you incorporate it into one?
What is that in the magistrate court with the automatic rent interdict? Does that application still exist? You did match court law. I'm not so up to date with that. There was an application for eviction with the automatic rent interdict or something like that. Does anybody know? Because I can't answer this person I can't answer Shasha, because I'm not 100% sure. But do we do it in the same proceedings? Well, we know that in terms of the PI Act, the Prevention of Illegal Evictions and Unlawful Occupation of Land Act, from Unlawful Occupation of Land Act, yes, the PI Act. In terms of that, if a person has to be evicted from their residence, you have to use the PI Act. Now, people usually use the application procedure. You talk about the PI application. But if you read the PI Act, you will see that you can also use the action. I've never seen PI a summons being used, but people usually use the PI application for eviction. And I think one of the reasons would be because an application goes quicker to court. I know in the magistrate court there existed the eviction and with an automatic rent interdict. You've done magistrate's court practice. Did you do it? Now everybody's quiet last night. Everybody remembered. Yes.
Sorry, it's Michelle. We do a lot of levy collections and that in the magistrate's court, and it's definitely not an automatic. Sorry about my daughter.
Okay.
But there's definitely no automatic rent interdict. We fight tooth and nail to garnish you a rental.
Do you claim it separately from the application for eviction?
Yes, we do.
In a separate action.
Correct. Yes.
So you use the PI application for the eviction, and then you issue a summons for the rent, or you abandon the arrear rent.
Correct. Yeah. We haven't abandoned. We do then get to section 65, etc. But yeah.
Okay. Yeah.
Yes. Sorry, it's Sasha again. But what, for example, happens if the arrear rent is it falls in the ambit of the jurisdiction within the High Court, and you also need to evict the people? That's what I actually want to ask. So now, for example, they owe a huge amount of money for arrear rent, and then you also need to evict them. How will it then work in the High Court? Is it then an application?
Well, if they owe you more than 400,000 rand, which is the monetary jurisdiction of the High Court, then I would issue summons for that arrear rental, separate from the PI application. You also bring a PI application in the High Court. I would, there isn't an automatic rent interdict, that thing that they had in the match court. I don't know if they still have it. I speak under correction. But in the High Court, that didn't exist. You would sue separately for the arrear rental. But remember I said, yes?
No, sorry, I just wanted to say, okay, perfect. No, thank you. Then I understand. So it's then two different proceedings and not, you can't just issue one proceeding or bring one application.
Yeah, you know, it is because the PI application is unique, because you can join different causes of action in the same procedure. You can have claim 1 for the eviction, claim 2 for the arrear rental. And I said to you earlier on that you can, if it's a liquidated amount of money, something that I just recently discovered, you can actually use the application procedure for that. Because I saw it was when people started suing people who owed them for road accident fund. Advocates were suing attorneys for owing them amounts of money, and they used the application procedure. And I said, but I thought you can never sue for damages with the application procedure, but you can if it's a liquidated amount of money. So in that case, you could have claim 1, claim 2, but I don't know how it's going to work, because the court will, with the PI application, there's a lot of other things that the court must consider, and it's got to do, it's usually people who cannot afford housing, yeah, and the right to house, constitutional right to housing. Right, somebody says here, let me interrupt myself. The landlord's hypothek is the right of a landlord to execute attached unmovable property belonging to the lessee. Yes, the landlord has a hypothek. So if you are in a rental arrears, the landlord can take your stuff. You can go to court and you can get an order, a magistrate's court issue it. You get a court order to have a hypothek, and then the tenants cannot remove their furniture from your premises until they have paid the arrear rental. Obviously, you can't put them out, but you can attach their property, and for as long as they are in arrears, you can keep that. So even if you have them evicted in terms of PI, you still can keep their property as a hypothek for what they owe you in terms of the rent. Yes, and that you can get quickly by the court. Yeah, security, yeah. Okay, thank you for that, guest. Oh, it's Quintus. Right. Okay, so we are going to first start with the action procedure. But now see that you've already done the application and the action. I want to switch over to application, because I think I should discuss. Do you know what the what is the name? The Plaskon-Evans principle is? Anyone? Or the Plaskon-Evans rule? Yes. Can somebody tell us?
Counsel, if I may have an attempt at it.
Yes, Janus.
The Plaskon-Evans case handles with two affidavits. So if in your affidavit there are material facts that are not sufficiently disputed in a reply, it would mean that the Plaskon-Evans case would find that the case has been made out based on the sole submissions made of an affidavit, if not sufficiently denied in a reply.
Okay. Yeah. Okay, that is an attempt. I usually deal with this aspect later on, but I want to deal with it. So I'm just going to go to that slide. So it doesn't matter when we do it, but we're doing the two separate ones. So I just want to quickly go there, and I'm going to come back to where I left you. Right. Because I said you must decide which you're going to use, which procedure you're going to use. Now, if you use the incorrect procedure, for example, you think you want to quickly get your matters heard by the court, and you decide to use the application procedure, right? And the court says no, but here's a dispute of facts on the papers. What happens? What can the court do? Right, here we go. Yeah, dispute of fact. So, and you only see this real foreseeable dispute of fact once you have the papers. Now, you would have learned in match court that you have the founding affidavit and you have the answering affidavit, right? These two documents are very important. in your, you will then from these two documents see whether there is a real dispute of fact. How will you see it? Because the applicant makes certain allegations in the founding affidavit. Those allegations, the respondent then react to. He will either say he admits it, he denies it, or whatever. He will respond to those allegations. Now, when do we say there is a dispute of fact? It arises where the respondent denies substantial factual allegations of the applicant and makes conflicting factual allegations against those of the applicant, which the applicant denies. Then we say there's a dispute of fact. And this is as a result of the decision in Room Hire versus Jeppe Street Mansions. I don't know if you remember that case, involved a brothel. That's all I remember about the case. But there they decided what was the dispute of when these things. Where the respondent admits substantial factual allegations, but on the other hand, alleges facts which the applicant disputes, then there's a dispute of fact. So the respondent admits certain things that the applicant alleges, but he alleges other facts, and the applicant then disputes that in the replying affidavit. Then we have a dispute of fact. Also, where the respondent alleges that he does not have knowledge of the allegations made by the applicant, but that the applicant or his deponent, now a deponent is a person who writes the affidavit, who deposes to the affidavit. We refer to that as a deponent. Whether his deponents are unreliable, untrustworthy, or prejudicial, and that certain facts upon which the applicant relies to prove the main facts are untrue. So he's saying, look, I don't know what you're talking about, but the people that made these affidavits, they are all liars. They are, and he makes that statement. Then there's still a dispute of fact. If the respondent just denies everything that the applicant says, but he doesn't make any counter allegations, then there's no real dispute of fact. Because he doesn't say he doesn't know it. He says, no, it's not like that. And he doesn't say how it is. He's not saying people are lying. There's no dispute of fact. Right. Now, if there is a dispute of fact on your papers, you now have used the application procedure, and now there has been the exchange of the affidavits. You must now argue it, but now from the papers, it appears that there is a dispute.
Your water bottle and you're taking out from your bag and give it to Nakwanda to wash.
Now you have to decide how you're going to deal with it. Now the court deals, if you've used the application procedure and you are before court, the court deals with a dispute of fact in one of the following 4 ways. The court's approach is it can either dismiss the application, and that is the worst thing that can happen, because then you lose if you're for the applicant. You don't get your relief. You're unsuccessful, right? Or the court can refer an aspect to oral evidence, that it must be that one of the deponents of the affidavits before the court must be called and put in the witness box and cross-examined so that they can get clarity and so that the dispute can be solved. You can also do that. Or the matter can be referred to a trial, where the founding affidavit now becomes the particulars of claim, the answering affidavit becomes the plea, the replying affidavit the replication, and then the parties conduct themselves further as if they are in an action. That means discovery, pre-trial conferences, all of that things that they must do, that must now happen. Right. Now, if you want the court, you see there's a dispute of fact on the papers, and you want to refer it to oral evidence because you don't want the court to dismiss, then you must bring an application. You must ask the court, can we refer to oral evidence? Because you must try and keep your matter alive. Or you can ask the court, can we refer to trial, and explain to the court why you didn't think that the dispute of fact was a real dispute of fact that could not be determined. Or it can be determined in accordance with the Plascon-Evans rule. Now we had, I don't know if it's Janus or Janus, I said Janus, explained to us his understanding of the Plascon-Evans rule. Now this is, I'm also now going to explain to you the Plasquan-Evans rule. It's very simple, it's not difficult. Right, if a dispute of fact is on the papers, right? Now how do you know what is the dispute of fact? Look at the respondent's answering affidavit. Look at everything that he admits. You know, it's paragraphs, and he will say, I admit paragraph 1, I admit paragraph 5, everything that he's admitting. Now you tell yourself a story. These are the common cause, means it's not in dispute. These are the common cause facts, or this is admitted by the respondent. So he admits all of this, not in dispute. Then you look at what does the respondent say further in defense of the application. And if what he says further doesn't take the respondent's case any further, or helps him, then the applicant is entitled to the relief that he asks for. That is the Plasquan-Evans principle. You look at what does the respondent say, right? And that is how it is described. The court is entitled to deal with the application on the undisputed facts. If notwithstanding that there are facts in dispute on the papers, the court is satisfied that the applicant is entitled to the relief in view of the facts stated by the respondent, together with the facts in the applicant's affidavit, which are admitted or have not been denied, it will make an order giving effect to such finding. That's basically what the Plasquan-Evans principle is. And then they've, in the SCA, in the case National Director of Public Prosecution versus Zuma, paragraph 26, the court again confirmed what the Plasquan-Evans rule entails. It said, motion proceedings, unless concerned with interim relief, are all about the resolution of legal issues based on common cause facts. Unless the circumstances are special, they cannot be used to resolve factual issues because they are not designed to determine probabilities. It is well established under the Plasquan-Evans rule that when motion proceedings, disputes of fact arise on the affidavits, a final order can be granted only if the facts averred in the applicant's affidavits, which have been admitted by the respondent, together with the facts alleged by the latter, the respondent, justify such an order. And then the court goes on to say it's different if the people are lying and all of that. So that is the Plasquan-Evans principle. So when you do choose the procedure, the application procedure, and there is a dispute of fact on the papers, and you now see it only once you have the answering affidavit, you see it, it's clear. You can also argue based on the Plasquan-Evans principle that the court should give you the order. That is if you are for the applicant. So you basically ignore your papers. This is what somebody said, basically just ignore your paper, what you say as the applicant. Look at what the respondent is saying, what is he admitting, and what does he say further? And if that story that he makes, that he tells the court there, convince or informs the court, yes, but then the applicant should get what he wants. Why should we fight about it? To give you an example, say for example, you always had a right of way over your neighbor's yard. Oh, I was not the neighbor. Over somebody's land. You always could walk there. You had a right of way. Talking servitude, but let's keep it simple. You always walked there for 20 years. You went, it was a shortcut, you walked there. One day you came and there was a gate and you couldn't go over that property anymore, right? So you go to court, you ask, obviously you first ask, remove the gate, why is the gate here? And you don't agree, then you go to court, you want the gate to be open because you want your right of way given back to you. So you make all these allegations. I walked there for so many years, and then this day there was a gate, no reason was given. And the respondent in his answering affidavit, he admits all of that. And then what does he say further? Further, he says, yes, I just don't like that he must walk there. It's been too long, or he says something stupid. And the court will say, no, but this guy should get his relief that he's asking, because what does the respondent say? He admits all of these aspects, and what he says further doesn't take his defense further. If he perhaps said further that, look, it is dangerous to walk there now because something happened, there's a hole or a sinkhole or whatever, and it's going to fall in it. I'm making this up as I'm going along. Then maybe the court will say, okay, the respondent says that further, the applicant shouldn't get the relief. So basically the court will look at what does the respondent say. Okay, back to actions which we are doing. Are there any questions, by the way? I'm not on you. Any questions? No. Right. We're going to do actions, right? And actions, you can divide it. It's not, this is just a rough division. I seen it in the textbook some years ago, and I thought it's good division. We have stage 1. It's the pleading stage. In the pleading stage, we define the issues. The issues are what we are fighting about. Issues are usually just issues, and disputes is the same thing. What are the issues? What are we fighting about? Right? It's no longer an issue, means the issue has been resolved. It's no longer in dispute. So in the pleadings, we define the issues. We see what it is that we are fighting about. Then when the pleadings have closed, we come to the pre-trial stage, where we prepare for the trial and we do the practical arrangements, like discovery, pre-trial conferences, exchanging of photographs, whatever we need to do for the practical arrangements of the trial, expert witness reports and the likes. Right. Then we come to the trial stage, where we have the actual trial in court, where evidence is placed before the court, evidence under oath. Witnesses come, they are taken through the paces of examination in chief. They are cross-examined by your opponent, and then you can re-examine if you feel like it. That is how evidence is placed on a record. And then the fourth stage is when the court gives a decision in his judgment. He must obviously, like I told you at the beginning, motivate his answer. So you must give reasons for the judgment. Must state why he accepts certain evidence and why he rejects it. If the court doesn't give a judgment, you can ask for a judgment in writing, and the court is obliged to give it to you 10 days after you've asked. Right. So the pleading stage is the argument stage. It's between the two parties in actions, the plaintiff and the defendant. The plaintiff would usually set out point by point in a document called the particulars of claim, what it is that he is, what is this cause of action, and what is he claiming, point by point. And the defendant will set out his defense to the claim, point by point, in a document called a plea. Just remember, plea and pleadings can sometimes confuse you. A particulars of claim and a plea are both pleadings, but a pleading is not necessarily only a plea. I'm confusing you. So you've covered this also with I presume, because it's exactly the same in the match court. You have 3 kinds of summonses: provisional sentence summons, a simple summons, and a combined summons. Right? Provisional sentence summons I'm not going to deal with now. You would use it if the claim is based on a liquid document. In that case, you need to know what is a liquid document. Does a document meet the requirements? There's a definition of liquid document. And only if you have the original document could you use the provisional sentence summons procedure. Then there is the other 2 summonses, the simple summons and the combined summons. Now, a simple summons you use if the claim is for a liquidated amount of money, and the summons usually includes a summary of the particulars of claim. So it is the one document which has a summary of the particulars of claim. For example, it can say claiming 250,000 Rand for goods sold and delivered to the defendant. That is a summary of the cause of action, because it's a liquidated amount of that you claim for from the defendant. A combined summons is 2 documents. You can see it's combined. It's a summons, which is a separate document, and then you have the particulars of claim annexed to the summons. So in the particulars of claim, the case is set out point by point. Simple summons, it's just a summary. Okay. You use a simple summons in these 5 instances. If the claim is for payment of a debt, if the claim is for delivery of specified movables, the claims is for transfer of fixed property, if it is for eviction, if it is for claim for the cancellation of a contract. And this eviction, they sometimes say ejectment, this eviction is people from commercial properties. It's not a residential property. You don't use the PI. You can use a simple summons. You never use a simple summons if you have to claim damages, right? Because how can you summarize damages? Damages suffered as a result of a collision to the value of 100,000. The court must still consider the damages, so you don't do it in a simple summons. A simple summons is usually signed by an attorney. You don't have to have right of appearance in the High Court to sign a simple summons. Now, I'm making this distinction here because when you sign a combined summons, it is signed by an attorney and an advocate. An attorney signs alone if he has right of appearance in the High Court. We dealt with that last night, and in terms of Section 25(3), in terms of the right of appearance in the High Court Act, you can get right of appearance. You must certify underneath your signature that you have right of appearance. Yes, there's some noise there.
Nokolo.
Thank you. Right. It's not gone yet.
Nokolo.
Is it Quintus?
No, it's not me, it's someone else.
Oh, okay. It's Nokolo. I can't seem to mute them.
Nokolo, please mute yourself.
But yeah, I could disable mic. It worked. Okay. Then you would also probably be able to do it. Anyway. You never use the simple summons to claim damages, right? I said that. But the signature, the summons it is not here, but probably somewhere here. Form 9 of the Uniform Rules is the simple summons. So it is a form to the Uniform Rules, and it has all the details. You obviously have to just fill in the details of your client, who is the plaintiff, and also obviously the summary of the cause of action. The summons must contain an address where the plaintiff will receive further notices and processes in the matter. The address now, this has changed last month, must be not more than 25 kilometers from the High Court, right? And if it is usually from the steps of the High Court as the crow flies. It used to be 8, then it changed in 2008 to 15, and now last month it changed to 25. I suspect the reason why it has changed, because remember, if you issued out of the High Court and your office was far away, you needed to use a correspondent attorney who would receive processes and documents on your behalf and would then send it to you. But now with electronic emails and electronic mails and yeah, you could just send it to the person wherever they are, so they don't need to have. But that is just me thinking that. So 25 kilometers from the court. And you also indicate to the defendant that if they wish to defend, how many days they have to file a notice of intention to defend, how many days to file a plea. Well, in the simple summons, you won't have that for the plea, but how many days they have to file a notice of intention to defend, and then What else? An address, and they must also indicate in the notice of intention to defend an address where they will receive pleadings. Yeah, and documents. Right, the combined summons. You can use a combined summons in every case. Even in those 5 instances where you may use the simple summons, you can use the combined summons. You can even use the combined summons if the claim is based on a liquid document, which will be the provisional sentence summons. Combined summons in each and every case. And next to the summons is a document setting out the material facts. The particulars of claim must be signed by both an attorney and an advocate. An attorney can sign alone when he or she has right of appearance in the High Court. Any questions? Right, processes can be issued now. I understand that the times are different for the various divisions, and I also know that we have people from right over the country in here, but usually from 9 to 1 you could issue, and I think you can still serve until 3 o'clock in some courts, but courts probably are all different with regards to when you can serve. You need to, you will quickly find that out when you do go and serve and file. Right. Service. Okay. This issuing, let me just stop there. We talked about the registrar being the custodian of all the court files. So you go and issue the matter with the registrar. So what they basically do is they open a court file, they give it a case number, stroke for the year in which it is opened, and they put that on your process. And this process can be either the particulars of claim, the summons, particulars of claim, and it can also be application, the notice of motion. But they will put the case number there, and that number is then allocated to that case, and every time subsequent to that first time when you had it issued, documents and is filed at court, then you must include that case number on it, because then they will know that it must go in that file. Okay, so you will file it, they will date stamp it, they will put it somewhere, and then later on a clerk will come, take all the things that need to be filed and put it in the correct files, hopefully in the correct files. Yeah, that's what they're issuing. Now, once you have issued your process, you have now the number, you take the original, and obviously, however many defendants or respondents there is, so many you have to have them date stamped, because the sheriff must go and serve this on the defendant or respondent. Right. Now the sheriff can effect service on any day from 7 a.m. to 7 p.m. On a Sunday or public holiday, they don't usually serve unless it is for an interdict or for a warrant for arrest or for attachment to found or confirmed jurisdiction. If there's improper service, then you can note an exception, right? Improper service means the sheriff didn't serve it in terms of one of the ways that he are allowed to serve. Now, this rule 4 is the uniform rule in terms of which the sheriff can serve and how it can serve. It is a criminal offense to obstruct the sheriff in the execution of his duties. Because sometimes when the sheriff wants to serve processes on defendants or respondents, the other people may try and stop him. It's a criminal offense. Okay.
Advocate, I've got a question.
Yes, please ask.
When it comes to being served by the sheriff, example, I work in government and you find the sheriff will want to serve the MEC herself. And you know what, these executives, they're hardly in the office. Is it a requirement that they really need to serve the MEC herself directly, or somebody in the office can accept? Because normally the sheriff will give a hard time to say, no, I need to serve the MEC herself. And these executives are never in the office.
And then doesn't he show? And he goes away and he comes again.
Yeah, he goes away with it and says he'll leave his number and say we must let him know when the MEC is in the office.
Yeah. I mean, in some instances, there should be personal service. It is not a requirement in I presume, the scenario that if it's for the MEC, they're suing government, but the MEC is cited as the defendant. They don't have to be personally served. They can leave it with somebody in charge of the office who can sign for it. And the sheriff can then put that in the return of service. But maybe the sheriff has a reason for not doing it that way. Maybe something happened. Or maybe there was a case where the MEC says that it wasn't served on her and the sheriff had to go and explain and prove that he did serve it, or something like that. But I mean, it's not a requirement unless the court has ordered or personal service in that needs to be done. But I mean, if it is in a capacity as representative of government and not in a personal capacity, then I don't see how personal service is needed. So it's probably just something that happened.
Thank you.
At Mankope, when serving one defendant, the rule is one original and 2 copies original for the court file, 1 copy for the defendant and 1 copy for yourself. When serving multiple, each defendant receives a copy. Yeah, you're right. KS, you are right. They don't need to be in charge. To the sheriff, they must just appear to be in charge. They don't have to be the manager of the place, and they must be older than 16. Yeah. So coming back to the service, it is the cornerstone of our legal system that a person is entitled to notice of legal proceedings against him. Remember, one of the principles that underlie the procedure in the High Court, where we have said that the audi alteram partem principle must be applied. You must listen to the other side. And how do we listen to the other side? Or how do we know that the court has listened to the other side? By notifying the defendant or the respondent, this is the proceedings against you. You can defend it. Come to court, do X, Y, and Z to show that you want to defend it. And if the court is satisfied that that was done and the defendant or the respondent does not come to court, then the court can be satisfied that the defendant or the respondent is okay with whatever relief is being sought against him, because he is now interested in defending it. Right. The following are processes that is directed to the sheriff. Directed to the sheriff means the summons will give an instruction to the sheriff. Please inform the plaintiff. If you look at the forms 9 and 10, 9 is a simple summons, 10 is the combined summons. So a summons for provisional sentence, which is form 3, this is pro forma forms in the uniform rules. A writ of arrest, this is a writ of arrest for contempt of court, civil contempt of court in the High Court. Form 4, a simple summons, form 9, a combined summons, form 10, a subpoena, form 16, a writ of execution, form 18, and a writ of attachment of immovable properties, form 20, a writ of commitment for contempt of court, form F, a writ of attachment ad fundandam jurisdictionem, to find jurisdiction, form H, notice of motion, that is form 2, and form 2A. Form 2 is the short form, form 2A is the long form. Applications for leave to appeal by petition in terms of section 21(3). Leave to appeal in terms of petition is to the SCA. It is a notice of motion. That is also served by the sheriff. Now, personal services, this might shed some light on your answer, ma'am, should be used whenever possible. Only use the other methods when the defendant is elusive or untraceable. So it is always top prize to use personal service. The sheriff, when he serves it, he hands the relevant document to the defendant personally. Where the defendant is a child under some legal disability, the process must be delivered to the guardian of that minor or to the curator, if the person has a curator. The court practice is that personal service is required in divorce cases, when the attorney seeks to withdraw as the attorney of record, then you must give the personal address of your client so that they know where to serve further. And there must be personal service so that it is known that the attorney is no longer the agent of the client, right? Any matter, for that sake, any matter which requests relief from the court, and if that relief is granted, the relief is going to, yes, I'll be with you now, the relief is going to change the status, like for example, a divorce, there must be personal service. Yes, sir?
I'd like to inject. Good day, good evening, advocates. I just want to know, after a default judgment has been granted by the courts, that should the next step be that we serve the default judgment, we file a default judgment to the sheriff to issue to the defendant? Is it so?
Just say that again. If default judgment is granted in court because the defendant didn't go, right? Then?
In an eviction matter.
Oh, in an eviction
I'm asking
matter.
the next step. Yeah.
Is it a PI application?
Yes, yes. So my question
is application by default. Okay, now they have a built-in, it's not a mechanism, but a built-in safety so that people are actually in PI applications advised twice that there's proceedings in court. First, the person gets the notice of motion served by the sheriff, and then after that, once you have obtained a court date, depending on whether it is opposed or unopposed, once you receive the court date, you must do a section 4.2 application again, asking the court, in camera, it's ex parte application, it can be in motion court, open court also, where you ask the court for directions for service. And usually the court will direct that there's personal service, if it is possible, on the respondents. And in that case, personal service is then given on each and every respondent who is about to be evicted. And that must be done not less than 14 days before the trial date. And in that notice, they receive the papers again, and they are also informed of their right to go to legal aid and their right to be in court on that court day to come and defend. So that the court must have been satisfied that that has happened when the court gives a default judgment. That is my take on that.
Yes, counsel, all that has been followed and done.
Okay.
I'm hearing you. Yes. So my question is that should we then file the default judgment to the sheriff? Because all those processes have been followed.
Should you file the default Should you file the default judgment?
Yes, to the sheriff to send it to the defendant.
Oh, to go and give it to them. Yes. Yes. The sheriff usually go and serve it so that they now get the court order that they must be out on a certain date, because the court would have determined when they must evict, when they must go from the property with a date. So the sheriff usually goes and serve that, yes. Because they weren't in court, so they don't know about it, about when they must be out. Because remember, the court is not going to necessarily accept what the applicant suggests. The court must take certain factors into consideration when it makes a decision. And if the parties are not there, the court is not going to ignore their rights. The court must still apply the law and the constitution. So the court will look at the facts and then make a decision as to what the court deems fair in the circumstances. The court won't punish them just because they're not there by saying now they must be out in a week or something. They're school-going children, the court might give some time. So they wouldn't know when they must be out, so the sheriff would have to serve it, yes.
Okay. Okay, thank you so much.
Okay, are you talking about a specific matter? Okay. Right. So I said that personal service must happen in divorces. Also, if I said if the relief is going to affect your status, an application for sequestration, there must be personal service on the respondent in that matter. And then in the PI application section 4.2, the court usually orders that this personal service, so that the court, before it gives the eviction order, knows that the respondents knew about the proceedings. This is personal service leaves gets first prize, but if that is not possible, the sheriff can leave a copy at the place of the residence or of the business. The document may be left with the person at the defendant's place of residence or business. If it's a self-employed, that's the business, provided the person is apparently in charge, like apparently somebody wrote on, deemed to be in charge, you don't have to be in charge, apparently in charge of the defendant's premises, and apparently not younger than 16 years old. So the sheriff don't have to ask the ID of the person and say, I want to see that you're 16 years old. Sheriff must just make a call. You look older than 16, I'm going to give it to you. Right. The service at the domicilium citandi et executandi, right? Now, the domicilium citandi et executandi is an address, that's a domicilium, which has been chosen by a person. It's often in a contract for the service of documents it's citandi, and the execution of judgments, et executandi. That's what that means. Once you've chosen in a contract, then it permits service even if the person has left the premises, since the aim of the election of such an address is to relieve parties of the duty to search for you if you want to effect service, right? Generally, the courts are reluctant to allow the use of domicilium addresses when the plaintiff is aware that the defendant won't receive notice of legal proceedings served at the domicilium address. There is instances where the sheriff goes to the domicilium et executandi, and that was given in a contract, and then the house no longer exists, or the residence is no longer there. What does the sheriff do then? He can leave it. In the past, you can leave it at the premises, and then the court must then decide whether he's going to accept that there was proper service. So if the sheriff gets there and the plaintiff didn't know, or there was no way that he should have known that the building is no longer there, the sheriff can either leave it on a tree or under a rock on the property. The SCA has ruled that the sheriff has, the court has discretion whether or not to accept service. Service on a company or close corporation is usually served at the registered office or its principal place of the business. Okay, and it can be handed to an employee or put on the main door. Then there's some notes about what a principal place of business is. You can just read that. Service on a partnership, it may be left at the place of business. A person who is apparently in charge and apparently older than 16. A local authority, it must be delivered to the town clerk, city manager, or mayor. The process must be delivered to the secretary or the member of a board if it is a statutory body. On 2 or more persons being sued in joint representative capacity, each one must be served separately, even if they live in the same house. Each one gets their own process. A legal proceedings against the state, it's usually, yes?
Sorry, I just want to quickly find out, just to go back to when you have to serve something, if your status changed, like a sequestration application, does that also have to be served, like, for example, on SARS?
Yeah, the court will direct, look with the sequestration, the court at the first time when you come to court, you do the application, and then the court will give a return date, or a rule nisi, as you would say, rule nisi, that is the return date, and then you must do certain things, and one of the requirements is that you must serve it on SARS. When you come, then you are provisionally sequestrated if the court is satisfied. Then when you come back, you must have done all of those and then convince the court that everything has been done before the court will make a final sequestration. Yeah. Okay. I don't know if that answers your question, ma'am. If you're going to sue the state, you must serve it on the office of the state attorney in that jurisdiction, right? If you are going to serve on a prisoner, you must first give a copy to the head of the prison. The head of the prison must then make the prisoner available for the sheriff so that the sheriff can serve him personally. Now, in some instances, you need to serve processes personally. Like, for example, a divorce. You need to serve it personally, but for some or other reason, you do not have the address of the person. People were married 10 years ago, the one spouse left and they just didn't bother with each other. And now it is unknown where this other spouse is, and the other party maybe wants to remarry or just wants to divorce, comes to you. You know that there needs to be personal service on the defendant. You try to find the defendant, you appoint tracing agents and all of those things, and you can't find the defendant. How do you effect personal service? You do an application to court for substituted service. This is substituted service is in to replace service, and you will then recommend to the court of a way that you propose the process must be served, and that if the court then allows you to serve it in that way, the defendant will receive it. So all you have to do is convince the court that whatever you propose will get to the defendant, to the notice of the defendant. You can be as creative as you need to be. So substituted service is ordered when the defendant is believed to be in the Republic, but one of the normal forms of service set out in the rules cannot be affected. The applicant must show that the court will have jurisdiction in the main action and that he or she has a prima facie case, and the whereabouts of the defendants are unknown. The applicant must state what steps he or she has taken to ascertain the defendant's whereabouts and that these have proved unsuccessful. He or she must show that there is some reasonable likelihood that the form of service suggested will come to the knowledge of the defendant. So an application, so it's a notice of motion. The relief that you pray for is that the court grants you substituted service, and then in the affidavit, you will explain how and you will convince the court why you think that will reach the defendant. Right. Are there any questions before I move on?
Yes, advocate.
Yes.
I wanted to ask on the substituted service point 2, where you say the applicant must then prove to the court that these are the steps they've followed. In a law firm I've once worked in, we used to ask tracers to try and locate the person. Yeah, but I left before that matter was actually finalized. So I don't know, are you basically saying that they would, example, we use tracers to find and we tried locating the person, it showed their recent address, but they were not there. So what happens in that instance then if you even attempted using tracers and they cannot locate the person?
Well, that is what you must show the court, because you mustn't just run to the court the first time. You must show the court that you can't reach this person. Then you must get creative. You must then say, usually in the past, what they did is it was published in a newspaper where the defendant last resided, and then it was deemed that he would have read the newspaper, and he has been served as such. You used to, I don't know if you still see it at the back of a newspaper on a Friday, you would see full divorce summonses. Yeah, that is where the defendant whereabouts are unknown. Now we have a lot of social media, social platforms. If you do know that somebody's active, but they refuse maybe, or they're not communicating with you, their address, you can suggest in the direct messaging or in the inbox or whatever that it is served, but you must then convince the court that it's going to reach him. So maybe say there's a recent photo. He's active here. It is him. It looks like it's been taken recently. He would get it if it is served on that way. You must say, whatever I've done to try and find him, it doesn't work. Traces also didn't find him, but this way will certainly come to his attention. Okay, it's time for our break. I need a break also. We get back at about 15:15 or 16 minutes past, but it's 1 minute past already. So I'll see you then.
Thank you.
Okay. Okay, so we are back and we move along, right? We finished off with substituted service. The next slide is the one 4 capital A, rule 4 capital A permits subsequent documents to be served electronically. Okay, so documents after the summons has been served by the sheriff, the following documents and pleadings that are exchanged doesn't have to be served by the sheriff. It can be emailed to your opponent. Obviously, you have to file it at court, but you can email to your opponent. Right. Now, the sheriff, when it effects service in one of those ways that we looked at, he must complete a return of service. And the return of service basically will just say what document the sheriff served, to who he has handed it, and that the person is apparently older than 16. Okay. So the return of service shall be prima facie evidence of the matters therein stated. The sheriff or the deputy sheriff must sign the return of service. It must state what documents had been served, and it mustn't be vague. If it is vague, the court can say it's a bad return, and the court can order that the sheriff serve again. Okay. That deals with service. If there's any question, no questions on service, then we move on. Just meant to mention this, if a defendant or a respondent refuses, because this happens, refuses to accept the document that the sheriff hands him, he's there, he says, yes, I'm that person, but he doesn't want to physically take the document, the sheriff can just drop it at his feet and then is deemed to be served. The sheriff will obviously have to write that in the return of service. Okay. Right. When you draft, now you've done this with Mr. Pitt, but you can do it with me again. I'm sure you did the heading. How do you draft the heading? Right. Now, where do you get the information as to what a heading must contain? This is not just somebody thought it out years ago and now everybody follows suit. No. Look in Rule 18 of the High Court rules. It tells you how you should draft. So it will say that the heading will have the name of the court who has jurisdiction to hear the matter, case number. Obviously, if you're going to draft your first document, you wouldn't have a case number. Only once it is issued by the registrar, they will put in the case number. In the matter between, and the plaintiff's name and the defendant's name, and then it has the 2 lines, the tram lines. Between those 2 lines, you will identify the document. Okay, that is how you draft the heading. From this, we can see the jurisdiction. We can see these 2 parties, and we will see whether they have locus standi. Yeah, and we will see what the document is, if it is a particulars of claim, if it's a plea, if it is a notice of motion. No, it can't be a notice of motion because there's a plaintiff and a defendant. If it is a notice to amend, if it is a notice of intention to defend, if it is a notice for discovery, you will see it in those tramlines, right? You can, the parties is cited, Rule 17. I've alluded to that last night. Tells you how you should cite parties. Now remember, if it is the plaintiff, then you must include the full names, the gender, the occupation, and the address. You can't say the plaintiff is Mr. Adams. You can't say that because the plaintiff is your client. You should know the full names. If it is the defendant, you can use the name by which the defendant is known to the plaintiff, because the plaintiff will tell you, I only know him as Mr. X. Then that is it what you say. The defendant is Mr. X. And you can say who's full and further particulars are unknown to the plaintiff. Obviously, you will have to have an address. Gender and the occupation is known. If you don't know what Mr. X does, if you don't, yeah, you would know the gender. Once had a long debate in a class about gender, about him, her, and they. We're not going to do that now, but people were asking, what if I don't identify as male or female? How are you going to describe me? Anyway, you can join
Sorry,
more than one party. Sorry, not anyway. Let me not jump from that without saying something. The rule has not been amended to include all the definitions of how people now are how the accepted norms are now, where people don't necessarily identify as male or female, but there are other kinds of genders also on the spectrum where people prefer to be called by those other names. So the rule has not been amended yet, so that is why we still just go by male or female. But I'm sure if you know that if the plaintiff tells you something else and what you think, then you put it in there. And it can't be wrong if that is how the plaintiffs identify. Right. Yes.
Isn't it also important to have the defendant's ID number? Because on the ID number, you will obviously also be able to establish whether it is male and female. But what if you don't have the ID number?
But you won't always have the ID number of somebody you sue. Say the dog bit you, and you now want to institute and they form a property. You don't know the owner of the dog's ID number. And the Rule 17 does not say ID number. I know that some people put the identity numbers in the particulars of claim. You don't have to. This is all that must be the full names, the gender and the occupation, the full names, gender, occupation, and address. So you don't need to know. But I mean, if you do have it, then you can see from that whether the person has been born, biologically born, male or female. Let me put it like that.
Okay,
Yeah.
thank you, Advocate.
Okay. Right, you can have more than one party. Parties who have a direct and substantial interest in any order the court might make in proceedings should be joined. You get a joinder of convenience where the issues that are in dispute depend on the determination of the same law and the same facts. Then parties can also be joined, but that is just for convenience. The first joinder that I mentioned, that where parties who have a direct and substantial interest in any order the court might make, that is a compulsory joinder. So if you receive a process and you see that somebody who, you look at what the relief that are requested is, and you see that somebody else's rights is also going to be affected, you can raise a special plea of non-joinder. Okay, so a party that has to be joined should be joined. And how do you determine if a party should be joined? Because that party, if the court should grant the relief that is asked, that party's rights will be affected. And because that party's rights are going to be affected, that party should be afforded an opportunity to come to court and to tell the court why his or her rights should not be affected. So that party should be joined as a party because we are going to court and your rights, we're going to do something to you. And you knew nothing about it, that is wrong. That would be non-joinder. You also get a case where somebody is joined that should not have been joined. And we refer to that as a misjoinder. Where somebody has got nothing to do with nothing, but their names also appear on the proceedings. Okay, so a compulsory joinder is somebody who must also be afforded the opportunity to protect their rights, because if you're suing, for example, somebody sold his house, and then another person wants to claim title of the house, so he wants to sue the person who sold the house. and then he sues that person for selling the house, he must also notify the present incumbent of the house, because that person, if the court gives his relief that the house must be registered in this plaintiff's name, he must also now move out. His rights will also be affected. So he must also be known in the matter so that he can come to court and protect his rights. I'm just trying to give you an example. Right? If there's more than one plaintiff, they are called co-plaintiffs. More than one defendant is co-defendants. Right? And this is how you would do it. You'll have a first plaintiff, second plaintiff, and defendant. And the same, you can have first, second. You can have as many as there are. There's no limit on how many plaintiffs and how many defendants there can be in a matter. I mean, those of you who've seen PI applications where people that live on a specific piece of land is in the hundreds. All of their names are listed. They are all then, it's pages and pages full of respondents. And it goes into the hundreds. Right. Now we're still in your consultation. You're still there in your office. You've now used that. This is a new client that comes to you. And he says, look here, the sheriff came to me and he served this document on me. You look at it, you see it's a summons. You say, okay, now what do you want to do? He says, I want to defend it because the sheriff said, if I want to defend, I must do stuff. I don't know. You, my lawyer, tell me. If you are going to defend it, the first thing that you do is you send a notice of intention to defend. Right? The notice of intention to defend is just a document indicating that you intend to defend. And in the notice, you must have an address within 25 kilometers of the court where you will receive further processes in the matter. Okay, and it is just you indicating that you are going to defend. And if you look on page 245 of your manual, there is an example of a notice of intention to defend. Okay, so above the tram lines, there would be the heading like you've seen before. This is the tram lines that identifies a document. It runs right over the page. This is not a good finger, but it says, please take notice that the defendant hereby gives notice of his intention to defend. So in this document, you don't have to say what your defense is. You don't have to now divulge anything. You just say, I intend to defend. Because you would have, in terms of the rules, you have 10 days in which to file a notice of intention to defend. $10 days. How do we compute days?
Court days excluding weekends and public holidays.
Yes, that is correct. Yeah, now I can't get into my slides. Okay, court days. If court days, which excludes public holidays and weekends. Those are court days, right? I don't know what to do here. Sorry. Yeah. Can you still see everything?
Yes, we can.
Oh, good.
Yes, we can.
Okay. Court
Yes,
days
we
are
do.
included in the computation of any time expressed in days prescribed by the uniform rules or fixed by an order of court. If the court says you must do something within 7 days or 5 days, and you want to count the days, it is court days, right? Non-court days are Saturdays, Sundays, and public holidays. If no time is specified and you have to do something, then that act must be performed within a reasonable time. And as we know, reasonable is a relative term. It can mean different things to different people. For someone, a year can be reasonable. For another person, a week is unreasonable. So the court will have to decide what is reasonable. But if no time is specified to do something in terms of an act, you must do it within a reasonable time. Or in the rules, if they say you must do something within a reasonable time, then you must do it in a reasonable time. If time is expressed in weeks or months, weekends and public holidays are included. So if the rule says that you must do something within 2 months, then you take a calendar, you include every day. Non-core days also, because it says, it talks about months. If time is expressed in terms of a statute, it must be computed in terms of Section 4 of the Interpretation of Statutes Act. Then you count every day. You count calendar days and not core days. So if you have to do something in terms of the rules, you count core days. If you have to do something in terms of an act, in terms of a statute, and they say you have so many days to wait. For example, when you send a notice in terms of Section 129 of the National Credit Act, the debtor has 10 days in which to respond. That would be 10 calendar days because it's in terms of a statute. So you would count weekends and public holidays. Right. Now, some of you, most of you would know how to compute, so just bear with me while I do this. The days that we get in which to do something in terms of the rules or an act, it is in Latin, it is referred to as dies indiciae, which means the days of grace. The days of grace that you have to do the next thing. So a notice of intention to defend must be served 10 days after the summons has been served by the sheriff. So how do we compute it? We now know it is in terms of the rules. So we must compute it. We must compute court days. So I have this example here. If a summons is served on a Friday, the 19th of March, 2021, we must now, not later than 10 days, file our notice of intention to defend. Now, the acronym, and some of you might know it, everybody might know it, is FOLI, first day out, last day in. You don't count the first day, but you do count the last day. But let me just get to you again. Do I need to explain this, or can I just go along? Do you already know this?
Please advocate.
Hey?
Please
Please
advocate.
explain it, advocate. We didn't do it in the magistrate court practice.
Okay, then fine.
Explain.
Okay.
You want to explain?
Okay, fine.
Explain,
No, I just don't
please.
want to waste your time. So the
like to
sheriff
know.
comes and he brings it on the Friday, the 19th of March. Now, the acronym that you use to remember how you compute is FOLI. It means stands for first day out, last day in. First day out means you do not count the day on which the sheriff brings it. Remember, the sheriff can serve from 7 a.m. to 7 p.m. He comes 7 o'clock, or he can come 7 in the morning, but you don't count that day. So first day out, you count. Your first day that you count will be your next court date. So it was served on a Friday, so you don't count that because of first day out. Then the weekend, you don't count the weekend because you don't count weekends. The Monday was a public holiday, you also don't count that. So your first day that you count would have been the Tuesday, that is the first day. Then you count all the normal weekdays, and then you don't count the weekends, and you don't count public holidays. And you would see from my example that the last day is the 7th of April. That is day number 10. That is the 10th day. That is the last day. Now it says first day out, last day in. On the last day, that is the last day of grace that you have to file. Right. So you can't count and 10 and then file it the next day, because the next day would be the 11th day and you will be a day late. So you don't count the day on which you receive it. You do count the last day, and that is the day on which you do the actual filing of the document. And in this case, it's a notice of intention to defend, which must be filed 10 days after it has been served by the sheriff. You do not count the first day, you count the last day, you do not count public holidays or weekends. Right. If the person, the defendant, resides outside of the jurisdiction of the court, then the jurisdiction of the High Court out of which it is issued, say for example, you were involved in a motor vehicle accident in Cape Town, so the cause of action arose in Cape Town, the Rationi Ray Kestai, cause of action arose here. You're going to issue out of the Cape Town High Court. The defendant lives in PE. He lives in the Eastern Kabeja. He lives in the Eastern Cape, so he has to be served there. Now he's not served in terms of the rules because he lives outside of the jurisdiction of the court. You have to serve in terms of the Act, the Superior Courts Act. I think it is section 23 or something like that. I speak under correction. Oh, it's 24. It says that when a person lives, I forgot, less than 150 kilometers from the court, then you must serve it within 2 weeks. If it's more than 150 kilometers, then it is a month. And in that case, because it's a statute, the Interpretation of Statutes Act applies, so you count calendar days. You use the same acronym, first day out, last day in. So you don't count the day on which the sheriff brings it, but you count each day. But just be careful. The last day in here, if you count calendar days, is where there's a caveat, a warning. If the last day falls, because remember you must count the last day if it is court days, but if the last day, if it is calendar days, falls on a weekend or on a public holiday, then you don't count the last day. Then you wait till the next court day. Why? Because the courts are closed on public holidays and weekends, and you are supposed to go and file it at court on the last day. So in that, then you don't count the last day, but it's only if the last day falls on a non-court day, then you don't count it. You use the same acronym, Foley. You use calendar days if it's in terms of a statute. If a person lives outside of the jurisdiction of the court, it's in terms of the Superior Courts Act. Count the calendar days, last day in, except if the last day is on a weekend or a public holiday. Yeah. Okay, so you'd be fine with that. I don't have any questions. You would know how to do that, right? Now remember there's a hand. Can I hear the question? Hello? There's a hand up. I see a hand. Okay, that person don't want to ask. Or unmute yourself. Unmute yourself, yes. Yes. Hello? Hello? Okay. Masete Stanley, you want to ask a question? Patrick Radzuma, you want to ask a question? Unmute yourself and ask.
Yes, I do. Can you hear me?
Yes, I can.
Yes, from the day of service by the from the day of service by the sheriff, can I still serve maybe earlier than the actual 10 days?
Yes, you can.
Oh,
you
okay.
don't have to wait until the 10th day.
Okay.
You can serve it on any day before that, but you have until the 10th day.
Oh,
yeah.
Okay.
You don't have to serve it on the 10th day. You can serve it on the first court day that you have. But if you do it like that, the next thing that you have to do is to serve, say a combined summons was used. You receive it, you want to defend, you file your notice of intention to defend, you do it on the very next court day. You have to now, within 20 days of that, file your plea. But you start counting the day after you have served your notice of intention to defend. That is why people often wait as long as they can so that they buy themselves more time to file the next document.
Oh, okay. No, thanks.
And if you're ready and you've got your plea and you're ready, do it as soon as you can. There's nothing wrong with that. Yes, Mr. Stanley Massetti. He's not here. His hand is just up. Okay. Right. So if a simple summons has been issued, remember now when we use the simple summons in those 5 instances for a liquidated amount of money, what is it? Delivery of movables, transfer of immovables, ejectment, and the cancellation of a contract. Those 5 instances you can use a simple summons. I said it is just a summons, it's Form 9. It has a summary of the cause of action. It can be signed by only an attorney. The sheriff goes and he serves the simple summons. The defendant has 10 days in which to file a notice of intention to defend. If the defendant files his notice of intention to defend within 10 days, 15 days after filing the notice of intention to defend, the plaintiff must file a declaration. Now, what is a declaration? A declaration is the same document as a particulars of claim, but it is called a declaration because it is used in this instance where a proceedings has been started by a simple summons. Why must the plaintiff then file a declaration? Because the simple summons didn't point by point set out what the allegations are. It just gave a summary of the cause of action. How is the defendant expected to defend that? He doesn't have enough information. He needs the plaintiff to set it out in further detail because he says, I'm going to defend. Look, if it's a liquidated claim, a debt, usually the defendant would know, look, I owe the money, so he wouldn't defend. But if the defendant is going to defend, he needs to be placed in a position where he can defend. So the plaintiff needs to place him in that position. The plaintiff would file the declaration, and now only the defendant must file a plea. That is now an answer to the allegations. 20 days after the plaintiff filed the declaration. And like I say, you have 20 days of grace, but you can do it in any of the days before that. And you compute the days, use the acronym FOLI, because it's in terms of the rules, it's court days only that you count. And 15 days after the defendant has filed a plea, the plaintiff files a replication. That is in the instance where a simple summons has been used, right? If a combined summons has been used, now you will remember that a combined summons has the summons and a separate document attached to it called the particulars of claim. If the defendant has 10 days in which to file a notice of intention to defend, and then because he's already in possession of all the facts, he must now plead. So he must, within 20 days after he has filed a notice of intention to defend, he must file his plea, and then 15 days after the plea was filed, the plaintiff files a replication. Okay, this is just a short note on what the declaration is. It is equivalent of what would have been the particulars of claim if a combined summons had been issued. It fully expounds the plaintiff's claim, not only concisely as in the case of a simple summons, but it sets it out fully. Right. I said earlier on that in the pleading stage, the defendant, if he has a counterclaim or a claim in reconvention, he files it together with his plea. It has also the same form as a declaration or a particulars of claim, filed with the plea, and usually you would refer to the parties as they are referred in the main action. Although the parties, the roles are now reversed. Because remember, in a counterclaim, it's usually filed by the defendant, but he is now actually the plaintiff in the counterclaim. And the plaintiff in the main action is now the defendant in the counterclaim, but they still refer to the parties as they are referred to in the first main action. So even though the defendant is a plaintiff, they will refer to him as a defendant. It is qualified by a paragraph at the beginning where it is stated the parties are referred to as before. Okay, so you don't, in a counterclaim, cite the parties again. You don't say the plaintiff is so-and-so and the defendant is so-and-so. You just say the parties are referred to because you're going to serve it together with the plea and it is going to run in the same action parallel to each other. Right. You can also, because it's filed together with the plea, incorporate anything that you've pleaded in the plea by way of reference. You can say refer to paragraph so-and-so of the plea. Then you don't have to repeat it in the counterclaim. The replication, 15 days after the plea, a plaintiff may not increase the ambit of the claim by making allegations in the replications which travels further than the allegations in the declaration and the combined summons. You may not increase the amount or state a new cause of action. So in the replication, you can't make out a new case. Deal with issues that are dealt with in the plea that you didn't deal with. It's part of the defendant's defense. You didn't know that, deal with that. Don't take your own matter further because you're not allowed to do that in a replication. You're not allowed to do that at all. You're not allowed to do it in a replication. Right. Now, I told you earlier on that there are further pleadings that can be exchanged. And this is now where I show you. 10 days after the plaintiff filed a replication, the defendant can file a rejoinder. And then 10 days after that, the plaintiff can file a surrejoinder. 10 days after that, the defendant can file a rebutter. And 10 days after that, the plaintiff can file a surrebutter. Now, you have 10 days after the replication to file each and every of these documents. If any of these pleadings are not filed within the 10 days, so the 10 days, and it is court days, expires and nothing is filed, then you can't now file it late. You are automatically barred from filing it. The pleadings have closed. Okay. I told you that Rule 18 will tell you what must be in the heading. Here it is, the title of the action, the description of the parties, and the case number or space for it, as well as the name of the relevant division shall appear as the heading. Now, if you are going to draft, every pleading shall be divided into paragraphs or subparagraphs and shall be numbered consecutively. It is very important that you do number each and every paragraph and please contain one fact per paragraph. If you need to contain more facts on the same aspect, rather use subparagraphs. And you'll see later why this is important. It's not just because of a matter of style. It is important that you don't contain too many facts in the same paragraph. Because if you do, remember, the defendant must plead to that. So the defendant say on paragraph 1, this is what I say. But this is what I say to that part and to this part, I say that and to that. It's going to become confusing. If there was just one fact, it would be easy for the defendant to respond, and then another paragraph, another fact. Or if you need to do sub-paragraphs, rather do it that way. So at the end of the day, when we look at the pleadings, it is easy to see what are in dispute. Right. When drafting any pleading, you must follow Rule 18. It is the general rule for all pleadings. Rule 18.4 says that the pleading shall contain a clear and concise statement of the material facts. Now, you are not allowed to plead evidence, right? You're only allowed to plead facts, the facta probanda. If you think back to your university days, the facta probantia is the evidence that prove the facts. Now, you plead the facts. You're going to lead the evidence at court during the trial. So in actions, you only plead facts, you don't plead evidence. Now, if you have a closer look at Rule 18, you will see that there are checklists contained in it. If you need to plea on specific causes of action. For example, if a claim is for breach of contract, Rule 18.6 will tell you what that pleading must contain. For example, it will state that if it's a contract, you must say who represented the parties. So you must say the plaintiff represented by Mr. X and the defendant represented by Mr. Y entered into a contract. And then you must say whether the contract that was entered into was written or was it oral, right? Then you must also state the contract was entered into in Johannesburg and the date and where, yeah, you must state where it was entered into and when it was entered into. And then you must say what the essential terms of the contract was. And a very important Rule 18.6 says, if the contract is in writing, you must attach a copy of the written contract to the particulars of claim. You would usually have a paragraph, and next year too is a copy of the contract marked Annexure A. Right, that is what Rule 18.6 is. That is, if it's based on breach of contract, and it's a kind of a checklist. The same is for the divorce. Look at Rule 18.8 and 18.9. Claim for damages for bodily injuries is Rule 18.10. Claim for death of another person, 18.11. Just coming back to Rule 18.10, there's a long list that you have to comply with if it is a claim for bodily injuries. Let me just mention a few. You have to, for instance, it says that you must state the name and the date of birth of the plaintiff. Then you must state the injuries that has been sustained. You must have different heads of damages. So you must state the injuries that has been sustained. Then you must state whether the injuries is permanent or temporary in nature. If it is temporary, then you must say for how long do you expect the injuries to last. Then you must state what is the sequela or the fallout or the consequences of this injuries. Because of this injuries, the plaintiff can't now bend down or whatever reason. You must also state specifically if there's past hospital expenses, if there are going to be future hospital expenses, what it is. You must state if there are a loss of income, past loss of income, that would be up until the date of the trial, and a future loss of income, looking forward from the date of the trial in the future and how long is going to be loss of income. Then general damages for pain and suffering. What did he suffer? Is everyday legs pain or whatever, you state that. What else is there? That a loss of amenities of life, like he used to play sport, now he can't do that. So Rule 18.10 have all that you must include in your particulars of claim. Right. If you do not follow the provisions of Rule 18, like for example, if the claim is based on a contract and you state they entered into a written contract, but then you neglect to attach the contract to the particulars of claim, that means you didn't comply with Rule 18. If you do not comply, Rule 18.12 says that such a pleading shall be deemed to be an irregular step. And irregular steps, we know, it may be set aside with the procedure set out in High Court Rule 30. You probably covered it under Rule 60 in the Match Court. It is the same procedure, irregular proceedings. Right, so I've just got summaries here of what you would have in your pleading. Now remember, you have your heading, you have your tram line, and now you're going to start drafting, because that is essentially what you're going to do in the exam, also in practice. So you first would start with the first paragraph where you would identify the plaintiff, follow Rule 17. Name, gender, occupation, and address, right? So you would have the plaintiff and then the defendant, however many there are, each one gets its own paragraph, right? From there, we can see whether they have legal standing, locus standi, and then you would have a paragraph to state why the court has jurisdiction to hear the matter. Now, in practice, people don't always include that the court has jurisdiction to hear the matter because it is apparent, if you read the whole document, it is apparent that the court has jurisdiction. But when you do your exam, put in a paragraph why the court has jurisdiction, because the cause of action arose there, or because the defendant is domiciled. If you don't know, just say the court has jurisdiction to hear the matter. Maybe they will mark it right. Right, then you describe the cause of action. Okay, so on contract, when it was entered into, where it was entered into, when, was it in oral, an oral or in writing? If in writing, attach a copy. Who represented the parties? What was the material terms, the obligations and performance that was tendered by the plaintiff? What was the obligations of the defendant? Was there a breach? What happened? Do you accept, are you going to cancel the contract, or are you going to enforce a specific performance? The consequences of the breach, what is the damages suffered, the quantum? If you had to comply with statutory or other pre-litigation requirements, so if you sent a letter of demand, just a normal letter of demand, you state, despite sending a demand, the defendant has still not paid. And then you have your praise. Wherefore the plaintiff prays for, and then you have your praise 1, 2, 3, whatever, however many there are. Remember, one of the praise are always going to be further and or alternative relief in the High Court. Remember the inherent jurisdiction of the High Court. And then costs, you always ask for costs. If you don't want to ask for costs, you leave it out. Right, if the claim is based on delict, do I have any questions? Sorry, before I move on. Any questions? If the claim is based on delict, again, the parties, from that the locus standi, the jurisdiction, plead the relevant facts, when, where the delict complained of, and the manner in which it was committed. Was there a duty of care? Is the breach of that duty of care? What is the consequences of that breach? What are you suffering because of that breach? What damages are, and like I say, Rule 1810 gives you the different heads of damages. Under each heads of damage, you must have a separate amount because you would need to prove each heads of damage. Quantum, that is if there's more than one heads of damage, right? The amount, compliance with the statutory or other pre-litigation requirements, and the praise. Right, so you are going to get an opportunity to draft during your casework week. I don't know when it is. And then you'll get an opportunity. Whoever is going to be your trainer there will okay. Do I have any questions? Any questions? No questions. So let's get back to our consultation. Yes, someone? Yes. Does everybody hear the noise? It's Slumla. Slumla? Was it you? Did you not want to speak? You just mistakenly put on. Right. You are in your office. You have now issued a summons. And the defendant has 10 days in which to file his notice of intention to defend. You know how to compute the days. First they're out, last they're in. The days comes and go, and now you receive no notice of intention to defend. What can you do? Now you can apply for default judgment. Right. Now, if the defendant does not file a notice of intention to defend, you don't have to contact him again and ask him, Where's your notice of intention to defend? Because he's already know there's a return of service on the document, on the record. He's not filing a notice of intention to defend, so he's not interested. You can apply for default judgment immediately without letting him know that you're going to apply for default judgment. In the instance where within the 10 days you do receive a notice of intention to defend, right? And now you sit and wait, you count the 20 days, you've used the combined summons, you count the 20 days on which for the defendant to file a plea. The 20 days passes, no plea is forthcoming. You can still apply for default judgment, but in this instance, because the defendant has indicated that he intended to defend, you can't just go to court and apply for default judgment. In this case, you must actually send him a notice of bar to say, you are late with your plea, but I give you 5 more days. And if you don't file it within 5 days, you are then barred from pleading, and then you will take default judgment against him. So you place him under bar only if he has given you an intention that he's going to defend. If there's no intention to defend, you can take default judgment just like that. You can, or if a claim is for a debt or a liquidated demand, you can apply to the registrar for default judgment. You don't have to do it in open court, right? If it is not for a debt or a liquidated demand, for example, if it's a claim for damages, then it has to be adjudicated on. The court has to make a decision. Then you have to apply to court, and you can't apply to the registrar. The registrar has certain powers to give default judgments, but only if it's for a debt or a liquidated amount. Default judgments are dealt with in terms of Rule 31 of the Uniform Rules, and this is the registrar's powers if he is the one that has to decide whether to grant default judgment or not. 31(5)(b) states that the registrar can grant the judgment as requested. He can grant judgment for parts of the claim only or on amended terms. He can also refuse judgment wholly or in part. He can postpone the application for judgment on such terms as he may consider just, or he can request and receive oral or written submissions, or require that the matter be set down for hearing in open court. He can say, look, I'm not going to deal with it. I think the court should decide on this. Now, if the registrar has determined default judgment and the party is not happy with the registrar's decision, 20 days after it has come to his knowledge what the registrar has decided, 20 days after which he has acquired knowledge, then he can set the matter down in court again, in open court. So it's not an appeal or a review, he just sets it down in open court because he's not happy with what the registrar has decided. Okay. This is now not a rescission of the registrar's judgment or order. It is just you have it heard in open court, which you always had the right to do, but you decided to go the quick route and now you're not happy with the registrar, you can let the court decide. This is what the notice of bar look like. You will also find this on page 245, which is 145. 245. There's an example of a notice of bar. This is what it says, and remember, this is you use this notice in the instance where the defendant indicates that he's going to defend, and then the 20 days in which he has to file his plea comes and goes and he doesn't file a plea. You send him a notice of bar. Please take notice that the defendant is required to deliver his plea within 5 days after the day upon which the notice is delivered, failing which the defendant shall be in default and ipso facto barred from filing a plea. Now, this days that the defendant has can, by agreement between the parties, be extended. So the parties can phone each other and say, defendant can say, look, I need more time to file my plea. Because there can be a myriad of reasons as to why you cannot file your plea. Maybe you cannot take instructions because your The defendant is sick, the defendant is out of town, or maybe you need to get the witnesses first and you don't know where they are. You need more time. Parties can agree, but in the case where parties don't agree, the plaintiff can place the defendant on bar, and they usually do that, place on bar, and then you have 5 days. So if the 5 days comes and go, what does the defendant do? He is now barred from defending. The defendant can go to court and bring an application to lift the bar. That is in terms of Rule 27. Yeah, where you ask the court to lift the bar, you must then demonstrate in your application to the court that the fact that you didn't file the plea is not a reckless disregard for the court's rules, that you have a good reason, on good cause, a good reason as to why it is not filed timeously, and that you should be afforded an opportunity to still participate, and that the default judgment should not be granted against you. And usually if you bring an application like that, in many cases, the court will grant the application to lift the bar and order that the defendant pays the wasted costs, because it is an indulgence by the court that is given to the defendant on its application. Right, so that's that. Can the defendant ask for default judgment? Well, in the case where a simple summons has been used, remember, the defendant files a notice of intention to defend, and now the plaintiff must file a declaration. But within the 15 days, it's come and gone, and no declaration is forthcoming. The defendant is waiting for this declaration because he wants to defend. Because it doesn't come, he can now place the plaintiff on bar and say that if you don't file the declaration within 5 days, I'm going to go to court and I'm going to ask for absolution from the instance. Now, absolution from the instance, you all know, is you are, as the defendant, you are absolved from the instance. You are absolved, you are pardoned, excused from putting your case before the court. That was what absolution from the instance means. You don't have to put your defense before the court. And when can you apply for that? If the plaintiff did not make out a prima facie case. Now, in this instance, because there's no declaration, there's no prima facie case. There's a summary of a cause of action, but no other information. It just says goods sold and delivered. It just does say when, what the goods were, when was it sold, who was there, who represented the parties, all of that information, which should have been contained in the declaration, is missing. So there's no prima facie case. The defendant has no case to answer. He is absolved from the instance. The effect of absolution from the instance means that you can institute proceedings again, provided that the claim did not prescribe. We all know that an ordinary debt prescribes within 3 years. A judgment debt prescribes within 30 years. A debt against the state prescribed within 15 years, but you can all look this up in the Prescription Act. Provided your matter has not prescribed, you can institute proceedings again based on new evidence and present a prima facie case to the court. But in that case, it is when the defendant can say there's no case for me to answer, so he files a notice of bar. Right. I've put this section here, but we're speaking about the hearing because it also deals with default judgment. If the defendant does not appear at the hearing, the plaintiff may apply for judgment by default against the defendant, provided that
Sorry, Advocate.
Yes, sir.
I'm so sorry to interject. I think there's just a really interesting question that came up from the chats here, from
I'm
Light.
not seeing the chats. Yeah, what does it say?
Yeah, and the question is, the only way to lift the bar is via an application. Can that happen by way of consent between the
Yes,
two parties.
by agreement between the parties. I said you can speak to each other and you can agree on an extension. But if the plaintiff don't want to and he still serves the notice of bar, then you have to approach the court. It can be by agreement between the party. I think Rule 27 says by agreement between the party or application to the court.
I think that sheds some light.
Yeah, let me see the question. I haven't looked at the questions. Yeah, my chats don't want to open. Right. I'll check it now. Failing to appear at the hearing. If the defendant does not appear at the hearing, the plaintiff may apply for judgment by default against the defendant, provided that the claim is liquid. If the claim is not liquid, the plaintiff may still apply for judgment by default, provided that evidence concerning the damage is tendered. Now, for those of you practicing in the High Court or going to the High Court, you know that we have this, don't know if it's a problem or an issue with the Road Accident Fund where they don't come to court on their matters because there's no attorneys on the panels and whatever. So plaintiffs still set matters down, and then on the day of the trial, the defendant is not there to defend. In that case, the plaintiff then apply for default judgment. But because it is damages, they must then provide the court with evidence. So they usually have heads of arguments, setting out all the damages, referring to the report, and then convince the court that this is the damages and that indeed they should get a default judgment against the defendant. So yeah, let me just see if I can see the chats right here by that fact.
Hello.
Yes.
Advocate.
Yes.
But concerning the last statement that you have been saying that if the defendant does not appear, the plaintiff can get a default judgment.
Yeah.
Remember, there was a case, I think it was during 2012 in Mmabatho High Court, where the judge refuses to grant default judgment to the plaintiff because it was that case. I think they were suing police for wrongful arrest. So he said, no, I want then over the state to represent their case here. So it was just like that. It was
the court
not
refused
granted
to
because
grant default judgment.
yes, they said the state must come this time around because it was maybe on 2 occasions when they didn't pitch. So it was the last and the third ones. But still, they went on to refuse to grant such judgment.
They went to?
So the court maybe is in the arena, is interfering, or what
Oh.
can we say? That?
Yeah, but yeah. So they took it on appeal.
I don't know. I don't remember.
Can you take a matter like that on appeal? Is it a final decision? Doesn't bring an end to the proceedings, eh? Just means they can set it down again. And you can only take final decision on appeal. And can the decision of the judge be reviewed? Because a judge's decision don't get reviewed. A magistrate's decision gets reviewed. Yeah. You're giving me a lot of things to talk about. Look, sometimes judges are careful, especially if the state's purse is the one that they have to now go into.
Yeah, their judgment
if it's
won't
public
be,
money and then they feel they want to protect public money. But now in the case with the Road Accident Fund, the roles in the High Court are full of Road Accident Fund matters every day. So the Road Accident Fund just didn't appoint attorneys and they didn't come. And it was too many matters for them to say, okay, now we're going to protect the coffers of the state and not give this orders. So they decided, they even have in Johannesburg a dedicated court to hear default judgments. And then practice directives were issued as to what you should do if you're going to ask for default judgment against the road accident fund. What should your papers contain? How you should do it. So there's even a dedicated court for that, just to get rid of it and to let the people come to the party and not just ignore court dates and that. Because if they're going to ignore it and the court is going to take the attitude that you say the court took in that instance, then yeah, plaintiffs are not going to be helped then.
Thank you.
Yes, there's another hand. Is that still that other hand of somebody who didn't want to speak?
No,
Oh,
good evening,
you.
Sawasha.
Yes. Yes.
Sorry, I just wanted to ask with regards to divorces, right? My assumption was that if it's not opposed, then you can get a default judgment. But does that mean that you'll have to apply on the unopposed motion instead of using the default judgment normal application? Would you need to enroll it for the unopposed motion so that you can get your default judgment? And then also, would you need the family advocate's report if there are children involved? That's one part. And the second part is, if, for example, you're asking for forfeiture of benefits, would the court need anything else more than what you have asked for in your papers simply because it was never defended?
Well, if a divorce is not defended, it go on the unopposed divorce roll. You don't ask for default judgment, but it goes on the unopposed divorce roll. And as I've indicated earlier on, it is usually heard with the unopposed motions. You would need the family advocate's report, but the family advocate don't give a report in each and every instance. They would only give a report and do investigations if there are problems in the matter. You serve papers involving minors on them. They look at it, and if they are satisfied with what the parties are agreeing on, they wouldn't do an investigation. If one of the parties wants them to investigate, or if they're fighting about the contact and the care issues, then they will do an investigation and a recommendation. So in the instances where they don't do a report, they would endorse the summons. So the court would want to see that the family advocate has seen it and that it is endorsed, so their stamp will appear on that. So not in all cases do you need a report. So you don't ask for default judgment in a divorce, you deal with it on the unopposed roll. Then, like I said, it's an action, so you would still call the plaintiff and you would still take them through the questions that you would usually ask. If you're asking for forfeiture, the requirement is that you must show the court that the other party is not entitled, that there was some kind of misconduct on his or her behalf. So evidence in that regard has to be put before the court will order a decree of divorce and incorporate those other praise in it. Yeah.
Okay. Thank you very much.
Okay. Right. Any more questions? No. Okay. Remember, you can also, if your client comes to you and say, I've just heard that there's a default judgment against me. I know nothing about the matter. And this do happen. It does happen in practice. It has happened. People don't know about the matter, and then the first time they hear of it is when the sheriff knocks on their door with a writ of execution and say, a judgment has been handed down and we are now coming to satisfy the judgment. Can you satisfy it? Can you pay it? And if you say no, they start attaching your goods. Then that's the first time that they hear. They come to see you. They were not aware of the default judgment. What can they do? You can apply for a rescission of the judgment, especially if it was given in their absence in terms of Rule 31, 6 and B. If it was given in the absence of the defendant, then you can apply for rescission of the judgment. You must then, in that application, you must convince the courts that you did not know about the summons. The summons was maybe served on somebody who didn't give it to you, or on the wrong address. You don't live there anymore. It was left in the letterbox or on the door or whatever, and it never came to your attention, and you didn't know. You would have defended it. So you have to convince the court that there's a good reason why you didn't defend. But more importantly, the court is not going to give you rescind the judgment if you don't have good chances of success in your defense. So you must convince the court that you have a valid defense that you could, if it's proved that you could win the matter, you could prove that the judgment should not have been granted. So the court will look at the merits of your case, and if you have good merits, the court can rescind the judgment. If you are going to lose in any event, the court will say, no, but what's the purpose of this rescission? Now, just a warning, if you are applying for rescission of a judgment, the rescission application does not suspend the execution of the judgment. Remember, if at the end of the case, if a party appeals a judgment, that suspends the implementation of that judgment. That with the rescission, it does not suspend. So the plaintiff can still go and execute on that judgment. The way to stop it is you must bring a separate application in terms of Rule 45 capital A, that is a suspension of a execution of a judgment. That is an application for the suspension of the execution of a judgment. So you bring that application, and you say in that application that you are going to bring a rescission order, or you're serving this together with the rescission application, so that if that order is granted, or then it will suspend, so that the sheriff can't then go and sell your stuff. Okay, that is the rescission. And then in terms of Rule 42, I just put it there because it's a rescission. You can also ask for a rescission of judgment in the instance where both parties were present in court, but the judgment that was granted contains a mistake that is common to the parties. Both parties were mistaken and they've given wrong information to the court. Now the court has to rescind that judgment. Or if the judge weren't placed in possession of all the evidence to give the judgment, right? Just check Rule 42. In what instances can the court overturn a judgment that it handed down? Yeah. Are there any questions on the rescissions? If the plaintiff does not appear at the hearing, the defendant can also ask for absolution from the instance. Remember, we dealt with if the defendant doesn't come, but in some instances, the plaintiff may also not rock up at court, and the defendant is there. The defendant can say there's no prima facie case against me. If the defendant has a counterclaim, he can ask for judgment in his favor, provided that he leads the necessary evidence to the court. Right. This is just a list of the documents, if you're going to not do it yourself as an attorney, but you're going to brief counsel, documents that must be in your brief. Yeah, and in all those instances. Okay, are there any questions? I'm going to end it there for tonight. I'm not going to start a new section. I just want to know from you if you have any questions as to what we did tonight.
Since advocate,
Willful default is the correct term. Yes. Yes, there's a question.
No, I was saying no questions from my side, but
Okay.
thank you very much for the informative lesson. And good
Okay.
night.
My pleasure.
Sorry,
Yes.
can I ask a question? I just want to know who drafts the plea? Is it the advocate or the attorney?
The advocate can be briefed to draft a plea, or the
Okay.
attorney can draft a plea. It doesn't matter. If you can't draft it, you can give instructions to an advocate to do it.
Okay.
Even
thank you.
particulars of claim, it can be drafted by any of the legal practitioners. But obviously, if it's a referral advocate, the attorney must refer the matter to him.
Okay, thank you very much.
Okay, thank you.
Hey, advocate.
Yes.
Yes, my question is related to savings of summons.
Mm.
There was this practice which I saw last time. That person was suing companies with 7 directors. So was he supposed to serve all 7 directors or only maybe 1 director or a manager?
Was it the company PTY Limited?
Oh, yeah, this is why I
Then
was.
the company is a juristic person. It's one defendant. Why did he serve in the individual directors of the company? Because the company is a juristic person and you don't go behind the corporate veil to the directors unless certain circumstances are met. You would just sue the company who is a juristic person.
Okay, and another thing which I have realized is that when mostly in matters of evictions, I realized that evictions regarding the commercial leases, I have realized that they are saving the directors and the person in his personal capacity.
If it's evictions
Yeah, for evictions, they are saving the director
of commercial property.
director himself personally.
Yeah, because somebody must move out. So obviously, the person who represents the company, yeah, they could serve the director. But are they evicting the company?
Yes, they are
Who's the
evicting the
party?
company from the building, and they
Yeah.
also save the personal person.
Yeah.
But he was not residing there. He's just.
But yeah, but he must know that the company must move. A person must know that this juristic person must move from the premises. Yeah, I can understand the thinking behind it.
Hello.
Yes.
Sorry, I think that in this instance, normally what would be happening is that in commercial contracts, the directors sign as sureties, right? So then, because they are sureties of the company, that's why they are served in their personal capacity.
In their personal capacity.
Yes, in
That
most
is in the
instances,
instance where
that's
there
when
are
I've seen them
surety. Yeah.
being- Yeah.
Yeah. Okay, it could be that could be also.
Okay, yeah, I remember. Yeah, now I remember. Thank you.
Also, where it's a partnership as well. I think you would serve on each partner.
Yeah, each partner. Yes, a partnership we would. But if it is a company, then it is a juristic person. Yeah. But like it was raised now by, I don't know, was it Lavona? Somebody said that it was where the director stand as surety.
It's non-Tobago, yes. Because I think in commercial contracts, there is that clause where the company needs to elect sureties for the commercial leasing of a particular property. So then that's why they are served in their personal capacities, because if the company is not able to then maybe, for instance, if it's a cancellation, their rent is overdue, then the creditor can be able to then go after the sureties in their personal capacity because they sign as sureties.
Where they've waived the requirement that they must first go after the principal before they go to the surety. Yeah, and in that case, it will be first defendant and second defendant.
That's correct.
Okay, yeah. There's another hand up. Okay, then that is that for tonight. I'll see you tomorrow. Good evening, everybody, or good night, everybody.
Good night, advocate.
Good night.
Good night.
Thank you very much.
Okay.
Good night. Good night.
Good night.
Good night.